Earlier this year, we sued Oracle in connection with an aggressive audit. What can you do if you're in a similar situation? What can you learn from that lawsuit? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For over 20 years, I have drafted and negotiated a variety of software-related agreements and litigated failed ERP implementations in courts across the country. So in this lawsuit, we made specific allegations against Oracle, and I can read here from the complaint. And what we said was, under its monetization scheme, Oracle would induce companies to click on buttons in pop-up windows to download an updated version of the software, and then claim that the company owed Oracle licensing fees under an Oracle Java SE Universal Subscription global price list, which was something that in our allegation, the customer had never actually seen. And then we go on to say commercial users, however, never indicated any agreement to the Java Universal Subscription. Neither of the pop-up windows nor one of the other agreements at issue contained any hyperlink to the subscription. In fact, the pop-up windows didn't even include a statement that by downloading the updated version of the Java software, that these commercial users were agreeing to this contract. And so that really was the basis of the lawsuit. We were saying, on one hand, we have no obligation to pay you. We never agreed to any kind of contractual terms, and of course, Oracle's position was, well, you did, and the terms that you supposedly agreed to are pretty onerous, and here's the payment structure that we're going to obligate you to. And there was a massive disconnect, and as you can imagine, the scope of use and utilization of this Java software was nowhere near, in our view, what Oracle was asserting. And so, this is essentially common practice. It doesn't matter who the vendor is. I mean, if you're dealing with Oracle, SAP, Microsoft, Infor, they're all going to approach these things similarly. There's going to be some sort of a communication audit letter, for example, to you that is going to outline what the scope of your alleged use is, the payment scheme associated with that. And at that point, I think you really want to slow things down if you get a letter like that. So here's what I would do. You really want to get a lay of the land, have an understanding of what the allegations are that are being made by that software vendor with respect to your scope of use. Make sure that you understand what you are using, and this is all before you reach back out to that vendor. I think your only communication at this point should be really a confirmation that you've received the letter from them, and then you've got to really do the deep dive into how you are using that software, who at your organization is using that software. You want to pull all of your contracts, ordering documents, the contract package in its entirety, and really go through that thing with a fine-tooth comb. Because I will guarantee you the way that software vendor is looking at those terms is going to be one-sided, unreasonable, and it's not going to be for your benefit at all. And there's going to be some vagueness in the interpretation of that contract most likely, and they're going to use that to their advantage. And your job at this point is really to have an understanding of the lay of the land, understand what you used, and understand how that relates to your contractual obligations, and importantly as well, is there some sort of pricing mechanism, pricing structure in that agreement that you can tie that use back to? Because and there should be, and once you calculate what the scope of your actual usage is, I guarantee your number is going to look a lot different than SAP's number or Oracle's number, and that then I think is really a basis for starting a conversation with that software vendor. Once you kick off communications with that software vendor, you really want to have one point of contact. You don't want to have multiple people interacting with the vendor. I think that's just a cause for confusion. You're going to have inconsistent statements. There's going to be inconsistent positions that are going to be taken, and none of that is going to serve you well. I think you want to have one point of contact. You're going to want to have an understanding of which legal entities on your side are involved. These contracts can be complex. There could be multiple affiliates that have a right to use the software under that agreement. And so if you get a handle on who needs to be involved in these conversations, that's going to serve you well. And then you're going to want to get an understanding of what their position is. clarify that that really is, what was outlined in that letter, to the extent anything was outlined in that letter, is really where they're coming from. Most often it's some sort of unrealistic number on purpose, made for the purposes of negotiating it down. I'd want to get an idea of where they're coming from, how real these allegations are. I'd want to have an understanding of what evidence they have. How did they make a determination that you were using the software either without authorization or beyond the scope of the authorization in the contract that you have with them? And as you're doing that, they may push back, and they may want you to run some sort of a script or some sort of functionality that scans your system, and you might be tempted to do that as a showing of good faith that you're not using anything without authorization. And I would caution you not to do that. I think you want to be in control of the information that is going out to Oracle. You don't want them to review your system, come up with additional theories or methodologies for calculating money owed to them. I mean, that's, to me, is a recipe for disaster, and that just doesn't make a lot of sense. And so once you've got an understanding of the lay of the land, once you've communicated with Oracle, you've narrowly focused your communication to just the decision makers on the Oracle side, I think you can start getting a sense of how real that number is, and you can start throwing around something that might be acceptable to you. And I will tell you from experience, I've been on both sides of these deals, and I've seen how these software vendors work. A lot of times, you are being targeted because they think you are an easy target, right? They think they can show that there was some unauthorized use of their system. They think that it's going to be provable, and your job is to make that not the case. Come armed with your numbers, come armed with your information, and push back as hard as you can. I do think that software vendors, they're not fans of suing their customers. So I think you've got a little bit more leverage than maybe you think you do. But I do think you've got to get a sense of how real that number is. You want to push back and see if there is any way to get that number to something that would be easy for you to stomach. Maybe your internal investigation reveals that, we did use something without authorization, and so maybe there is some reasonable payment that needs to be made to Oracle. So that is something that I think you can consider, but a lot of times these software vendors will try to utilize audit results, aggressive auditing of the system, in order to get you or to induce you into the purchase of some sort of a new product, or to sign you up for additional years, or something along those lines. And the negotiation would go like, okay, well, you owe us $250,000 for this unauthorized access to the software system, but we'll give you a 50% discount. But you also have to license 3 more additional years of whatever product or whatever shiny object they're trying to push on their customers. And I think that is where you really want to take a step back. And I think that's probably an indication that this is not made in good faith. And if that is happening, you really want to watch out. And so, the next step, I think, is when do you get your lawyers involved, or when do you get some sort of specialized consulting firm that deals with this particular vendor and has experience in pushing back on audit requests? And really, I think once you get an understanding of the lay of the land, I think that's going to dictate how far you're going to want to take this. For example, if it looks like, we really did do something here, we authorized something without authorization, then maybe it's enough that you get it resolved and you can negotiate some sort of a reasonable payment. But if this thing is just way off base, or the money involved is astronomical, I think that's the point where you want to consider not just getting a consulting firm involved that has experience dealing with audit issues. You're probably going to want to get a law firm that specializes or focuses in dealing with lawsuits involving that particular vendor that you're dealing with, because that then, I think, is a whole different ball of wax. And you might want to, from a negotiation standpoint, you might want to initiate a lawsuit like we did in our case for our client. That is certainly an option. I think that many times can be what I would call a nuclear option, because you don't know what is going to happen. But I will tell you this, most of these vendors, they're engaging in these aggressive auditing schemes, particularly without basis, or as a means to induce you to purchase additional products. They do not want these tactics to be exposed in court. They don't want to be precluded from doing them. So I think if you do get into a situation where you file a lawsuit, it's going to be additional leverage for you. You're going to be able to utilize the filing of that lawsuit to your advantage to try to negotiate down any liability that they're claiming you have to them. So, it is certainly a viable option. I don't think litigation is something you want to enter into lightly, certainly, but in certain scenarios, it certainly makes sense to utilize it as a strategic tool in your toolbox, and that's certainly what we did for our client in this situation. Look, if you have any questions about anything I discussed in this video, please feel free to reach out to me at taftlaw.com. I'd love to talk to you and get you pointed in the right direction.